And I thought, man, this is going to go all the way to the Supreme Court. You know, it took 20 seconds to realize that this was a perfect test case. Why Tecumseh?
Tecumseh, Oklahoma, is a town of about 6,000 people, located 35 miles southeast of Oklahoma City. Many residents commute to the city, although there are still a few farms and ranches. Gloria Trotter, editor of the local countywide news, explains that Tecumseh is well known for its schools.
We have been very proud of our school system over the years, and it has attracted a lot of teachers, administrators, and even families moving into the area for the school system.
But as in all schools, there was concern about drug use. In 1998, a parent asked the school board to address what she saw as Tecumseh's drug problem. School board members Dean Rogers and Terry O'Rourke recall those early discussions.
Her son was taking drugs, and he was an athlete. And she was trying to get something done because she said there were others down there that was taking drugs too, which we knew, that there was drugs in the school. There was no doubt.
We had had some issues at school with some drug problems. Some drug paraphernalia had been found. Drug dogs hit on some cars and locker, that type of thing.
It was clear at that point that schools could legally test athletes, but the school board was interested in a broader policy.
I didn't think it was fair to test just the athletes when there's other organizations out there that are having the same problem. And they said, well, with athletes you can get hurt. And I said, in ag you can't get hurt if you have a 1,500-pound steer.
The other thing that concerned us, these youngsters were sending off to different parts of the country representing our school system. We certainly want to make sure that they're representing us in the right way.
The school board members decided to consult their lawyer, Linda Mioli, to determine how far they could go with drug testing. Mioli specialized in representing school boards.
The assistant superintendent gave me a call and said they were considering a drug testing policy and faxed it up to me, and I looked at it, reviewed it.
In 1995, the Supreme Court had approved drug testing of athletes in the Vernonia case. The court had held that because the high school in Vernonia had a serious drug problem, there was a special need for drug testing. Since the Vernonia decision, a few lower courts had permitted more general testing of students, but the issue had not yet come before the Supreme Court.
So there was some basis to drug test all students in extracurricular activities, and that's what Tecumseh wanted to do, and I reviewed it and said, you're subject to a challenge on it, but you've got some cases behind you.
The school board scheduled a public meeting to get input from the community. They found there was substantial support for the new policy.
And there were, I was trying to remember, I mean, about 50 people there maybe. It wasn't a huge crowd. And there was only one person in the entire group who had anything negative to say about the policy. Everyone else spoke in support of the policy.
Bolstered by parental support, the school board approved a policy for drug testing of all students involved in extracurricular activities. All students were to be tested at the beginning of each school year and then randomly selected for testing during the year. They would be called out of class and taken by a teacher to the bathroom to provide a urine sample. The first time they tested positive, they would get counseling. The second time would result in a 14-day suspension from extracurricular activities. A third positive test would result in suspension from those activities for the rest of the year. Tecumseh's policy would have a tremendous impact on one of its students, Lindsay Earls. Lindsay was a sophomore when the policy was adopted and active in a number of extracurricular activities.
I was in choir and I always liked it, and my friends were all in choir, and then as I continued on I thought, this is a kind of a good thing. Colleges like to see that you are active in these activities, so the more I have time for, the more I'll do.
She was upset when she received notice about the policy.
When I first heard about this policy, I almost thought they were kidding. Who do they think they are, thinking they can make me pee in a cup to sing in the choir? What kind of performance-enhancing choir drugs are there? I don't understand. Most of the other students' reactions were kind of, it's not that big of a deal, Lindsay. We know you're not using drugs. Just take the drug test and get it over with. So I took these notes home saying, if you want to continue being in choir, you have to take a drug test. I took it home and said, Mom, Dad, what do you think about this? I really don't think this is something that that is fair, that is right, that is even legal.
First thing I remember when she came home talking about it was, "Dad, can they do this? Can they make us do this?" And I said, "Well, I don't see why they could." We were active enough with our kids. I knew what they were doing. I mean, I didn't need anybody to tell me that I needed my kids drug tested. So at that point, I told her, no, I really didn't think they could do this. And why did they want to do it to start with?
I never expected my parents to say, just sign it, just take the drug test.
You had parents that basically want the school to do the job of the parent.
David Earls talked to a few local attorneys, but no one was interested in taking the case. He tried a different approach.
ACLU came to mind. They'd litigated a lot of cases, and I felt this was a civil rights type case. So I wrote them a letter explaining what was going on because it didn't make any sense to us.
Earls' letter to the American Civil Liberties Union came at a good time. The ACLU had just established a new national program located in New Haven, Connecticut, to challenge a variety of drug-related laws and hired its first director, Graham Boyd.
The ACLU Drug Policy Litigation Project was founded to use the possibility of litigation and the court system to try to rein in some of the excesses of the war on drugs. While drugs themselves are a very serious problem in this country, the war on drugs, the things we do to fight against drugs, sometimes have even worse costs.
One of the ACLU's priorities was to limit drug testing in schools. They were concerned that testing would expand as a result of the Supreme Court's Vernonia decision.
Overruling Vernonia was not really the issue. It was more about making sure that it was limited to athletes. It made sense to really think strategically about how to frame a case that would have the best facts to have it end up before the court.
Boyd began looking for the right case. He contacted the ACLU's local affiliates asking for leads, and the Oklahoma branch forwarded David Earls' letter. He followed up immediately. Boyd flew to Oklahoma to meet with the Earls family.
It was pretty surreal. I left school early that day, and we drove to Oklahoma City, my parents and I, and went to the ACLU, and we met this man who said, "This is a big deal, guys. This is a case that could possibly even go to the Supreme Court if you're willing to go with it that far." And I thought, the Supreme Court, are you serious? I thought maybe you could, write them a letter and say, stop testing this girl, leave her alone, and then it would be over with.
Boyd decided that Lindsay would be an ideal plaintiff.
First of all, it was clear that this was an issue that they all cared about as a family. It wasn't just a child who wanted to do it and the parents were not supportive. Quite the opposite. In a small town where that would be a controversial position, that kind of unity would be very important.
He also liked the geographic venue. Oklahoma is located in the 10th Circuit, and that court had recently decided against the government in a Fourth Amendment case.
So the fact that there was a case already there that had been decided that struck down drug testing, that made litigating in that circuit with that particular precedent especially appealing.
The 10th Circuit has a reputation as being a very liberal court, so I think Graham made a decision that, hey, the 10th Circuit's not bad. So we were the chosen ones, I guess to say, that Tecumseh wasn't very happy about.
After careful thought, Lindsay agreed to be the lead plaintiff in a civil rights suit against the Tecumseh School District.
She did exactly what I would have wanted her to do, but at the same time, this was going to concern her day-to-day life at school. I didn't have to go to school, so ultimately it was her decision.
The suit was filed on August 18, 1999 in federal court in Oklahoma City, where it was assigned to Judge David Russell. From the beginning, the case attracted national attention.
This could have just been an anonymous case, but for some reason it struck a public chord. It had interesting legal issues that had not been definitively answered.
Attracting media attention was part of Boyd's strategy.
We only do a relatively small number of cases here. They are almost always cases of national importance and national interest. And so I think it's inevitable that there's going to be press attention. I think that's a good thing. I think that the way that democratic values and education in general is advanced is by engaging in these public debates.
The high level of public notoriety bothered many in Tecumseh.
The way we found out about it was because the ACLU called the New York Times and NPR and told them about it. They didn't tell us.
Today, a high school student in Oklahoma plans to file suit in federal court against her school's mandatory drug testing policy.
The next school board meeting, there's a reporter from the New York Times at a Tecumseh school board meeting. That kind of blew everybody away.
I was upset because these people I've known for 35 years, that they wouldn't come to us and try to sit down and work something out.
Small town Tecumseh does not like a lot of publicity, and certainly this is a case where we got more publicity than we've ever had.
School administrators chose not to comment on the case, and Mioli agreed.
I don't want to try a case in the media. I think it's for the courts to try, and so Graham and I really did have a completely opposite attitude about how we were going to try this case.
It's very frustrating from a journalist's point of view, because if you're trying to present a balanced story, you want to talk to both sides. But the superintendent wouldn't talk, the assistant superintendent wouldn't talk, the board members would not talk at that point at all. Graham Boyd talked. I got the ACLU side just fine.
The town's anger was directed not at the Earls family, but rather at the ACLU.
This is a pretty conservative part of the world, and there wasn't a whole lot of sympathy for the ACLU, to be frank about it. There was a lot of resentment, in fact.
When anyone thinks of the ACLU filing a lawsuit, it's obviously in a negative manner. They're young lawyers trying to make a name for themselves.
In this day and age, people need somebody like the ACLU to fall back on. The ACLU's got a lot more resources financially and legally than an individual would have.
For the Earls family, the days after the suit was filed were difficult.
It was really stressful for me, being a shy person and being someone who'd grown up in this town, sheltered and loved in this small town, to say, you know what, Tecumseh, I think you're wrong, and I want you to stop this, and for the whole town to look at you and say, we can't believe you're doing this. Why are you turning against us?
And they come up and they say, how can you challenge the system? What are you thinking? It's our job as citizens to challenge government and rein government in when we think it's wrong.
The case was decided quickly, without a trial. The parties agreed that the facts were uncontested, even if their legal significance was debatable.
The Earls case was, on its facts, different than Vernonia in literally every single way except for the fact that it involved school children. Athletes, non-athletes, dangerous versus safe activities, students using drugs versus students not using drugs, a school with a drug problem versus a school with no drug problem.
It's really not that different. You're dealing with athletes who have a lesser expectation of privacy in Vernonia, and you're dealing with children and students in extracurricular activities that also have a lesser expectation of privacy rights. So the expansion is not that great.
Boyd's primary argument was that in Vernonia there had been a drug epidemic. In Tecumseh, that just wasn't the case.
Vernonia itself had some extraordinary facts. It was a school that was deemed by the courts to be literally in a state of rebellion. The school had tried everything that it could do. Nothing was working.
Their epidemic problem was really not that dissimilar to ours. We just didn't call it an epidemic. Whether you had one child or 120 children, it was still drug abuse.
Absolutely not an epidemic. Absolutely not. Do we want it to become one? Absolutely not. I lived on a street here in Tecumseh that is right across from Slick Humphrey Park, which attaches to the high school. I could watch youngsters in the park during lunch smoking marijuana. I would always think, what if that's one of my kids down there?
In deciding the case, Judge Russell was convinced that the school, perhaps like all schools, had at least a drug problem, if not a drug crisis. What was important to him was balancing the students' privacy interests under the Fourth Amendment with the school board's special need to protect children.
I saw a special need here just from the standpoint of these were very young people living in an environment where there is a serious drug problem in Oklahoma. And there's not many days go by I don't sentence somebody, some young person who's destroyed their lives on drugs. If a school wants to experiment by trying drug testing, it seems like a logical thing to do.
Another contested issue was how invasive Tecumseh's policy was of its students' privacy.
People weren't supposed to know that you were going to be drug tested, but when someone walks into the classroom and says, you know, these 5 students need to report to the high school auditorium, everyone knows you need to go to the high school auditorium so you can pee in this cup they're going to hand you.
Your sense of privacy may be very different than my sense of privacy, and yet courts have to somehow or another draw rules that apply to you and me and everybody else equally. I think it's probably true that Lindsay's sense of privacy or propriety might be a bit stronger than some of her peers. It is uncomfortable to have teachers whom you know standing immediately outside of your bathroom stall listening while you urinate, and then handling the urine sample and pouring it from one vial to the next. There's just something about that that's uncomfortable, especially to an adolescent girl.
At some point in life, nowadays you don't get a job without giving a urine sample. I mean, it's just almost mandatory anywhere you go.
Again, Judge Russell sided with the school board.
It didn't strike me as a major intrusion. Everything I saw in the case was that even though it was an intrusion, it was not something that was so substantial that anyone would be humiliated by it.
Losing at the district court was not unexpected. Boyd immediately filed an appeal. In March 2001, a divided panel of the 10th Circuit ruled in Lindsay's favor. The court found that because Tecumseh did not have a serious drug problem, there was no special need that justified the testing. Judge David E. Bell, one of the 3 10th Circuit judges deciding the case, recalls the arguments.
One of the compelling arguments that Ms. Earls made in the case was, she said, look, if you have somebody on drugs, the best way to get them off drugs is to keep them busy in school. On the other hand, I saw the school board's very compelling policy that, my goodness, parents trust their kids to us. We take them on trips. We engage them in relatively less supervised outside activity, and we've got to be able to tell our parents that these kids are in safe hands. Those are very conflicting public policies, and who am I, as a judge, to make that decision? And I much preferred to have that policy made by the school board.
Judge E. Bell disagreed with his fellow judges and decided to write a lengthy dissent.
Usually, you waste your time writing dissents because you're not setting the law. But in Earls, my purpose was to attract the attention of the U.S. Supreme Court. I thought it was an important issue. I thought the Supreme Court needed to decide it.
After losing at the 10th Circuit, the school board faced a critical moment. Up until then, all costs had been covered by insurance. That policy, however, had a $100,000 limit, and all the funds had been spent. The school board members had to decide whether they would be willing to pay to take the case to the Supreme Court.
We called Linda and I said, okay, Linda, where are we going to end up on this thing? So we estimated around $50,000 to complete through the Supreme Court. We need to finish what we've started.
So we voted to go to the Supreme Court. Bake sale, car wash, whatever we have to do now to go on. Sometimes you just have to do what you think's right for the kids and the community.
Mioli filed the petition for certiorari, and the Supreme Court granted review, preparing the way for a judicial showdown between privacy values and local officials' authority to take action against drugs.